Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. Today we're going to talk about how to prepare for a trial if you have a custody establishment case. So first we'll cover how do you set a case for trial. Next we'll get into your list of witnesses and exhibits. Then we'll talk about the notice of issues, the pretrial statement, your trial outline, which is optional, but I highly recommend. And then what to do if the court orders you to prepare and lodge a proposed order based on the judge's findings at the trial. So first, let's look at setting a case for trial. This is under Rule 77. The court can set a trial on its own. That could happen on a resolution management conference or at a scheduling conference. But if your case has not been set for trial and you would like it to be set for trial, then you can do this motion to set. And your motion to set needs to include the date by which you'll be ready to proceed to trial, the names, addresses, and telephone numbers of the parties or their attorneys who will be conducting the trial, whether the trial is entitled to preference because it involves legal decision-making or parenting time, and how long you estimate the trial will take. Generally, you're looking at 1 hour, 2 hours, 3 hours. That's around a half day or a full day. It can be tough to get a full day setting, in particular in Maricopa County, but you can put down the time that you request. The judge can always decide the ultimate amount of time, but you're not going to request a week or something like that. You're likely looking at a half day, a full day, or something less than that. So just keep that in mind. Here's the court's form for the motion to set for trial. You'll see if you read through this, it includes all of the different points that are required under the rule. So you would just fill this out and then sign it, file it with the court, and then provide a copy to the other side. Now, here's the list of witnesses and exhibits. Now, whether or not you need to do a form like this is going to depend on what the court ordered, but you are going to need to file your exhibits with the court pursuant to the court's rules and by the deadline set by the court in the order setting the trial. So just make sure you're really clear on what's required regarding exhibits and make sure that you follow all of the rules related to exhibits by the deadline. If you're going to do this, like we could call it a cover sheet for the list of witnesses and exhibits, this is a form that you could use. You're going to tailor this to your case and you'll want to edit all of the parts that are in red, but here's where you'd list your witnesses and then here's where you would list your proposed exhibits. And then this would get filed with the court and a copy to the other side. Okay, so we talked about your list of witnesses and exhibits and how important it is to get your exhibits filed with the court on time and pursuant to the court rules. And then there's also this form called a notice of issues. It contains a complete list of all the contested issues that will be presented at trial. Issues not raised previously cannot be raised for the first time in the notice of issues, and each party must file a separate notice of issues. The issues listed in the notice of issues are listed generally. Specificity is reserved for the pretrial statement. And what the court is wanting you to do is to file your notice of issues and then communicate with the other side and see if there's any of these contested issues that can be resolved, and then work together on the pretrial statement if you're doing a joint statement. Keep in mind, neither party is required to file a notice of issues before a temporary orders hearing or other interim hearing. So this is just for a final trial, a final evidentiary hearing where the court is going to rule on the petition and establish custody. When is the notice of issues due? That is due 20 calendar days before trial. And then the pretrial statement is due 5 business days before trial. Here is the court set form for the notice of issues. So this is going to be establishment of paternity or maternity if that's an issue in your case. And then establishing legal decision-making if you haven't already resolved that in your case. Establishing parenting time if that hasn't been resolved in your case. establishing child support, and then whether or not attorney's fees are at issue. That's what's going to come up in a child custody establishment case. Any other issues in your case you could put here, fill out your mailing certificate, and then this would get filed with the court 20 calendar days before your trial date and a copy mailed to the other side. Let's look at the pretrial statement. A pretrial statement can be a joint or a separate statement. The parties need to see if the court is ordering a particular type of pretrial statement. So look at your trial setting order and see if it says anything about the parties must file a joint statement or if the parties can file separate statements. If you're preparing a joint statement, then the petitioner, the party who initiated the action, must take the lead to prepare a draft joint statement and must communicate with every other party concerning the statement. And what the petitioner is supposed to do is provide their outline for the pretrial statement to the opposing party 15 calendar days before the trial. Then 8 business days or more before the hearing, the parties must exchange their respective portions so that the positions can be merged. The pretrial statement will be reviewed by both parties and filed no less than 5 business days before the hearing date. So you'll want to calendar all of these dates once you get your order setting the trial. Every pretrial statement must be signed by each party or counsel. However, if the parties are self-represented and there's a history of domestic violence, the parties must file separate statements. And then just remember, the notice of issues is due 20 calendar days before trial. The pretrial statement is due 5 business days before trial. The pretrial statement needs to include a lot of different information. This is the first slide with the information. We'll go through one more slide. And then you'll see in the set form, which we'll get to in a minute, has all of this in there as preset parts for you to fill in. So a brief description of the nature of the action, each party's name and address, if not confidential, the name and date of birth of each minor child at issue in the case, the parties' stipulations or agreements, if any, a statement of uncontested facts or law, if any, detailed and concise statements of the contested issues of fact and law, and then your position on each contested issue. Spousal maintenance would not be an issue in a child custody case, so you don't need to worry about that. Parenting time would be at issue if you haven't already resolved that. So if parenting time is at issue, then your proposed parenting time schedule, including what you want the court to order for holidays and vacations, and why your parenting time schedule is in the best interest of the child. And then your list of witnesses you intend to call at trial. If there were any depositions done during the case, designating the deposition testimony that you intend to use, each party's list of objections to any witness and the basis of each objection, a list of the exhibits that each party intends to use at trial, specifying exhibits that the parties agree are admissible at trial, or if not in agreement, listing the objections and the specific grounds for each objection that a party may make or will make if the exhibit is offered at trial. A statement by each party confirming that all pretrial discovery and disclosure has been completed by the trial date, and if the parties have exchanged all exhibits and reports of experts who have been listed as witnesses. A statement as to whether the parties have in good faith discussed settlement, and if not, the reasons for not discussing settlement, any request for attorney's fees, and a statement of how a verbatim record of the trial will be made. There's also certain attachments that go with the pretrial statement. So if your case involves child support or attorney's fees, then you need to attach your affidavit of financial information. And then for child support, if that's at issue, your proposed child support worksheet with the amount of child support you're asking the court to order. Keep in mind that the pretrial statement and the notice of issues are really important because you're not allowed to present a witness or offer an exhibit at trial if you didn't include it in your pretrial statement, unless the court allows you to after a showing of good cause. You waive the right to raise an objection at trial or hearing if the specific objection to a witness, exhibit, or claim is not raised in the statement, in your pretrial statement. And a party may not present an issue not listed in either party's notice of issues at trial unless the court orders otherwise for good cause. So take your time with these documents, make sure you've included everything, every witness, every exhibit, every objection, and make sure you file everything by the deadlines so that you don't get any of your witnesses or exhibits excluded due to a failure to list. Let's look at the pretrial statement form. So you can do a joint statement or a separate statement. And this is where you're just going to start filling this out according to what's involved in your case. Indicate when your case is set for trial, how long the trial will take, the parties, their contact information, the date of service of the petition, the names of the minor children at issue in the case. For witnesses, you can include an additional document with your list of witnesses and your objections to the other party's witnesses, and I'll show you that form as we get through this document. Same thing with the exhibits. There's a form to list out your exhibits and any objections to the other side's exhibits, and we'll look at that page in a minute. And then here are the attachments. So attach your affidavit of financial information, and then attach your proposed child support worksheet if child support is going to be decided at your trial. Anything that you agree upon, any uncontested facts, and then what are the contested issues of fact or law? What is the petitioner's proposal to resolve those? What's the respondent's position or detailed proposal to resolve those? Whether or not pretrial discovery and disclosure has been completed. Have you exchanged copies of the pretrial statement? What efforts were made at settlement, if any? And then the verbatim record. This is where you can indicate that you want the record to be kept by the court's recording system called the FTR Gold system, and or a court reporter if the court provides one. But generally, the record's going to be kept by the court's recording system. Fill out your mailing certificate, sign, fill this out. And then here is the petitioner's exhibit page with any objections. Now, if you have more than 12 exhibits, you can copy this page and then update the numbers accordingly. Here's a respondent's exhibit page, and then petitioner's witnesses, respondent's witnesses. And then, of course, you would attach your affidavit of financial information, your proposed child support worksheet, if child support's at issue in your case. And also, if, let's say, child support's resolved, but legal fees are at issue in your case, then you need to attach the affidavit of financial information. All right, now let's talk about the trial outline. Now, the trial outline is not required by rule. It is not filed with the court. It is not exchanged between the parties. This is a document just for you, and this is optional, but I highly recommend it. This is your script to use during the trial to make sure you make all the points you want to make, and to also make sure you get all of the exhibits in that you want the court to consider. So here is an example trial outline if you're the petitioner. So here, this is where you would type in your brief opening statement, and then you get into your case. And let's assume you're going to testify first for your case, and you don't have a lawyer, so you're just going to get up and testify. You don't have anyone to ask you questions. This is where I recommend you really get into detail in this part of the outline and make bullet points with each point you want to make. You can incorporate in any exhibits you want to present. And it's great if you can use what I call signposting, where you let the judge know what you're going to talk about. So you can say, now I'm going to talk about legal decision-making for our children. And then if you're requesting sole legal decision-making, explain why. Why is that best for your kids? That's what you would testify to. If you're requesting that the court award you and your co-parent joint legal decision-making, why are you asking for that? Why is it best for your kids? And then you can indicate, now I'm going to talk about parenting time. This is where you could present an exhibit with your proposed parenting plan, and then talk about why your proposed parenting plan is best for your children. And you can go through the 25-403 factors that apply to your case and explain why your parenting plan is best for your kids. And then for child support, now I'm going to talk about child support. This is where you can present your proposed child support worksheet as an exhibit. You can present your affidavit of financial information as an exhibit. You could present your co-parent's affidavit of financial information. And then explain each number you used in your proposed child support worksheet, where you got that number from, why you used it, and explain to the judge the overall amount of child support you're asking to be ordered. And then what are you asking the court to do about medical insurance for the kids? How do you want uncovered medical expenses for the kids divided? How do you want the child tax exemptions divided? Are you asking for any past child support? All of that should be covered here in the child support section. If you're requesting an award of attorney's fees and costs, or if the other side is requesting it and you're objecting, then in this section here, you can put in arguments about what the court should do about requests for legal fees and costs. You can talk about financial resources and reasonableness, because that's what the court's going to be looking at. According to the law, the judge can order one side to pay the other side's attorney's fees, either all or in part, if one side has more financial resources than the other, and or if one parent has been unreasonable during the case. Then you'll get to the end of your testimony. This is where you're going to want to give the judge a summary of what you're asking the court to do to resolve your case. After you testified, you're subject to cross-examination. And once cross-examination is over, you're subject to redirect, where you can say anything else that you want based on what came up on cross-examination. So if there's anything that you want to clarify or go into more detail that came up in cross-examination, that's what you would do on redirect. Now, if you want to call your co-parent to the stand, you could do that next. You don't have to, but you could if there's some point that you want to prove through them. And then in this part of the trial outline, this is where you would draft direct examination questions for your co-parent. If you have any other witnesses, this is where you're going to want to draft questions to ask those witnesses at the trial. Once you're done presenting your case, then it moves to your co-parent's case, the respondent. And you'll want to prepare cross-examination questions for your co-parent when your co-parent testifies. Your co-parent could call you to the stand during their case. If so, you would take the stand and answer the questions that are asked. And then if your co-parent is going to present any other witnesses, you would want to prepare cross-examination questions for those witnesses. As the petitioner, you do have the opportunity to present any rebuttal evidence once the respondent is done with their case. And then you get into closing arguments. And when you're drafting your trial outline, it can be helpful to start with your closing argument to really bring everything together and give you the big picture of what you're looking to do during the trial. So I recommend you start there, but you don't have to. I just find that that is a very helpful way to start. Okay, so now let's look at the trial outline for the respondent. Use this outline if you're the respondent and you have a custody establishment case. So if you're the respondent, then that means the petitioner is going to go first. So you're going to want to draft cross-examination questions for the petitioner. And these, you can break them up into categories. What are the cross-examination questions I want to ask about legal decision-making, about parenting time, child support, attorney's fees, any other witnesses the petitioner is going to present? You can prepare cross-examination questions for those witnesses. And then once it's your turn to present your case, this is where you can draft your direct examination questions regarding legal decision-making, parenting time, child support, whatever issues are going to be heard at your trial. So whatever is unresolved at the time of trial. Attorney's fees, you can add in information about that. And then any other witnesses that you're going to present, you can prepare questions for them. And then your final part to draft is your closing argument. So that's the trial outline for the respondent. Now, let's say you go to trial and the court makes findings and rulings and the court orders you to prepare a proposed order establishing. Well, then what you're going to do is you're going to draft a notice of lodging. You're going to draft the order establishing legal decision-making, parenting time, and child support, in which you put into that what the court what the court's findings and orders were, parenting plan according to what the judge's orders are, your child support worksheet, child support order, and the income withholding order. The income withholding order is an order to the parent that's ordered to pay child support. It's an order to their employer to take a certain amount of money out of their paycheck and send it to the support clearinghouse. And then it goes to the parent entitled to receive the child support. So that's the form that makes all of that happen. Here's what a notice of lodging looks like. I didn't find one of these in the Maricopa County forms, but I did find it in the Yavapai forms. So this is just a cover sheet that goes on the proposed order establishing. And by lodging it, that opens up an objection period. So you do the notice of lodging and your proposed order, and then the other side has 10 business days plus 5 straight days to file an objection if they object to anything that's in your proposed order. Here is the court's set form for a proposed order to establish legal decision-making, parenting time, and child support, or if child support's already resolved and you just did legal decision-making and parenting time, you could check this box. So you would fill this out based on what the court's findings and orders were, and then the court ultimately would sign here. Let me go back. Would ultimately sign right here once the lodging period has passed. Now, attached to this order is the parenting plan. So you'd fill this out with everything that was ordered by the judge. And then the child support worksheet. This would contain all of the numbers and the final amount of child support that the court ordered. The child support order in support of the child support worksheet. This is filed as a separate document. It's not attached to your order establishing. It's an additional document that's filed with it. And then in Maricopa County, there's this current employer information form. This is filled out and it's used in the income withholding order. And then in Yavapai County and many other counties, we use this income withholding for support documents. So you fill this out, it's 5 pages long, and that also gets filed with the court. Okay. All right, that brings us to the end of today's video. So just as a summary, keep in mind that if the court hasn't set your case for trial, you can ask the court to schedule a trial date by filing a motion to set. You'll want to prepare your list of witnesses and exhibits if that's been ordered by the court, otherwise your list of exhibits, and make sure you prepare all of your exhibits according to the court rules and file them with the court by the deadline to submit your exhibits. The notice of issues is due 20 calendar days before your trial date. Your joint pretrial statement is due 5 business days before the trial date, and you can do a joint or separate statement depending on your situation and what the court has ordered. The trial outline is optional, but it's something I definitely recommend. And then, and keep in mind with the trial outline, it's not filed with the court. It's not exchanged with the other side. This is just for you to use as a script during your trial. And then if the court orders you to prepare a proposed order for the judge to sign with the judge's findings and rulings from the trial, then you can do the notice of lodging and the proposed order establishing. All right, I hope that was helpful. If you have any questions, please bring your questions to the Q&A.